Okay, sorry, the mysteries of
during the phone call. Thank you for your attention.
Thank you, Mr. Fox. Now call upon the respondent to present on the issues of procedure and late delivery.
Yes, Mr. Presiding Arbitrator, members of the Tribunal, good morning. My name is Thalie Benveniste, and I represent the interests of the respondent, Equatoriana Clothing Manufacturing, with my co-counsel Clément Hurstel. I will now address the issues of procedure and late delivery. About the procedure, the respondent agrees with the claimant's submission that the tribunal has jurisdiction to hear this matter and that the IBA rules are applicable to this case. Now, about Mr. Short's witness statement. The respondent believes that the tribunal should not disregard such statement for 4 reasons. The first reason is that the respondent believes that Mr. Short had a valid reason to not attend the hearing, and also that in any event, these are exceptional circumstances. The claimant argues that the fact that Mr. Short has a really busy timetable is not a valid reason not to come at the hearing. The respondent reminds the tribunal that there is no legal or legal definition or case law about valid reason, and that the tribunal has the discretionary power to determine whether the fact that Mr. Short is really busy is a valid reason or not. But in any event, the most important element is that Mr. Short does not work for respondent. He works for Jumpers Production, and respondent doesn't have the power to compel Mr. Short to attend to the hearing. So this can be considered, in respondent's opinion, as an exceptional circumstance. And so,
excuse me, counsel, could you, I understand what you said, but could you help me here? Why do you say that Article 19.2 of the model law, to which your colleague has referred, why do you say we wouldn't have the power, Article 19.2 of the model law, to do what you want us to do?
The Article 19.2 of the model law gives the tribunal a discretionary power to determine the admissibility and the weight of evidence. So I was just saying, Mr. Arbitrator, that the tribunal has the power to determine if it's a valid reason or not.
Okay.
May I proceed?
And is there a difference between actually admitting the statement into evidence without Mr. Short appearing, and how we then consider that evidence? Do you say that we apply different tests in respect to consider whether we should admit, and then subsequently what weight we should be giving that evidence?
Yes, Mr. Arbitrator, that is correct. It is my next point, actually. So, may I proceed, please?
Okay.
Thank you. Yes, so the respondent believes that Mr. Short's witness statement should be admitted into evidence, and that, but that the tribunal should determine the weight it gives to this evidence. The Article 19.2 of the model law, which we just talked about, gives the tribunal the power to determine the weight of the evidence. So there is no need to disregard the statement. The tribunal can admit the statement into evidence and then give it, for example, less weight because Mr. Short could not be cross-examined. And if the tribunal did not admit Mr. Short's witness statement into evidence, the respondent believes that it would be a breach of the principle of equal treatment of the parties, which my learned colleague just talked about. Indeed, the claimant would be able to present a witness, while the respondent would not be able to present a witness, and so would not be able to present its own case. That leads me to my fourth reason for admitting Mr. Short's witness statement into evidence. Failure by the tribunal to admit the statement of Mr. Short into evidence is a ground for setting aside the award and refusing its recognition and enforcement in virtue of Article 34.2 of the Model Law and 5.1b of the New York Convention. Because the respondent... Yes? Yes, Mr. Arbitrator?
Sorry. Are you going to take us to those provisions?
Yes.
Are you going to... Thank you.
You want me to read those provisions?
Well, I'd like you to explain them to us, yes, please.
Well, the Article 34.2 of the Model Law and 5.1 of the New York Convention give the tribunal the power to set aside the state courts the power to set aside an arbitral award if there is a breach of procedural fairness and if a party is unable to present its own case, because this would be a violation of due process.
Why do you say you would be unable to present your case on the basis that Mr. Short's statement is not before the tribunal? Why does that make you unable to present your case? Haven't you got documents to prove?
Yes, we've got documents, but Mr. Short is the only witness of respondent, and the tribunal can give, if it deems it appropriate, no weight to Mr. Short's evidence, so there is no need to disregard his statement. And it is international practice in arbitral tribunals to admit a statement if the witness does not come, but to give less weight to the evidence. And this happens... Yes?
Could you ask, excuse me, could you give the tribunal some authorities upon which we'd like to consider some authorities which support the proposition you just made? You made some reference to which authorities do you rely upon in respect of those statements?
Okay. For example, in the SD Myers case of 2002, the NAFTA Arbitral Tribunal ruled, and I quote, the written testimony will not be ruled inadmissible, but the tribunal is likely to attach little or no weight to the extent that it is not corroborated by witness evidence. So that was a similar case, actually. The witness did not come to the hearing, but produced a written statement.
Do you know in that case whether the IPF rules were used?
No, I don't know, Mr. Arbitrator.
Thank you.
May I proceed? Sorry?
I don't quite understand why go to the full of admitting the statement if you could readily concede that it was to be given no weight?
Well, that is for the tribunal to decide, but this statement is important because it is the only witness statement of the respondent concerning the phone call conference, the phone call of the 9th of February, sorry. And this phone call is important in determining whether there's a late delivery or not. And moreover, Danubia is situated in a civil law jurisdiction system, and in civil law, cross-examination does not exist, and written always prevails over oral. So,
surely on the facts, don't we have before us in the record that possibly, we haven't made a decision on this, but I read the record, the conduct of Mr. Long in going about changing the dates on other documents. Why wouldn't that be good evidence? Why wouldn't it be enough for you, in the sense of because we obviously are going to allow that evidence the claimant, isn't it?
So your question is, why should we admit into evidence Mr. Short's written statement when we have Mr. Long? That is your question?
Exactly.
Okay.
Yeah.
Well, because the ability to present its own case is also the ability to present the respondent's version on the telephone conference, even if the two versions are quite saying basically the same thing. There's no real difference, but the parties stated in the procedural order number 2 that both of them could not remember the exact wording. So that's why the respondent argues that the cross-examination of Mr. Short is not essential, but that his written statement should be taken into account.
I suppose it does raise the issue as to what we're going to find is the meaning of the word all the paperwork, which I referred to before, page 37 of the record, paragraph 4, when I was asking Mr. Bob this very question.
Yes, that would be well. It is that leads me, if you permit, to the issue of late delivery. If I may proceed with this issue.
Certainly.
Okay, thank you. On the late delivery, the respondent believes that first there was an agreement between Mr. Long and Mr. Short to change the delivery date of the contract, and that second, this agreement led to an oral modification of the contract. Now, I think, the respondent thinks, there is no doubt in the fact that Mr. Short and Mr. Long agreed to change the delivery date, even if Mr. Long agreed to it because he had no choice. But there was an agreement because he changed the delivery date to the 24th of February in the shipping contract and in the letter of credit. So if he didn't agree, he wouldn't have changed the documents and would have avoided the contract directly. Now, Mr. Long said, as Mr. Arbitrator was saying, that all the paperwork would reflect the new delivery date. What would a reasonable person in the place of Mr. Short understand by this sentence? All paperwork, it's the letter of credit, the shipping contract, and the contract in itself. That's what a reasonable person would have understood. But
was the contract itself modified though?
No, the contract wasn't modified actually, by written form. But the respondent believes it was modified in the oral form, because it is common.
Oral brief, isn't there a difference between requesting or requesting a changed delivery date, which would you expect be reflected in the contract, and accepting late delivery, which would be reflected in the other document? Isn't that what happened here?
Well, the respondent believes that the contract was orally modified because it is common international practice to avoid excessive exchange of documents to be more efficient. Mr. Long only modified the delivery, the shipping contract, and the letter of credit because those two documents needed to be modified in order for the delivery to happen. And the contract in itself did not need to be modified in writing and have an exchange of documents between the two parties for the delivery to happen.
Why is that? Can you address us on Article 96?
Sorry, I did not hear your question.
Can you address us on Article 96?
Oh, yes, of course.
What?
Well, as the claimant believes that Article 96 prohibits the contract to be modified in writing. However, only one of the two parties has made the Article 96 reservation. And in this case, the majority view of authors and case law considers that the tribunal, that this reservation should be put aside and that the tribunal should use international conflict of law rules to determine the national law applicable to the form requirements of the contract. In the present case, Article 35 of the CISG provides that the method to be used to determine the national law applicable to the case should be the closest connection method. This is an international sales of goods contract, and in such contracts, the characteristic performance happens in the country of the seller. The seller, in our case, is Equatoriana. The contract was signed in Equatoriana, and the closest connection method leads to the national law of Equatoriana. Equatoriana, who has not made the Article 96 reservation. Therefore, in Equatoriana, the contract can be modified orally. And therefore, since there was an agreement between Mr. Long and Mr. Short, the contract was modified orally. And since the contract was modified orally, the claimant can't claim any damages regarding late delivery, and this is my final point. Thank you.
Thank you. Your time is up. Any questions? Okay. Thank you very much. We can now ask the council for